Good evening to you all. Thank you for being here. Ori, thank you for introducing us and framing this moment. It's hard to say, both because of that context and because of politically where we are, that it's a delight to be here. And yet, despite all of that, it is. And I want to especially thank Professors Siegel and Greenhouse for giving of your time. And you're both extremely busy, especially in this season. The date is chosen because the 22nd of January is the annual anniversary of the Roe v. Wade decision from 1973. It's on the eve of its 49th year. And I want to thank Professor Siegel for teaching me that and suggesting that this is a season, and a kind of a fraught one, a momentous one for considering the legacy and the fate of that. So just a word about who these two remarkable scholars are. Linda Greenhouse, to my left on the Zoom screen, is a clinical lecturer in law, senior research scholar at the Yale Law School, and covered the Supreme Court for the New York Times for 30 years. She won numerous awards, including a Pulitzer. And you can check out her recent book, Justice on the Brink, which is all over the place right now. And to my right, Professor Reva Siegel is the Nicholas B. Katzenbach Professor of Law at Yale Law School, the author numerous books and articles on the 19th Amendment and the regulation of abortion in America. And they both have been people who over my time here have been generous hosts in welcoming me to Yale, and scintillating and thought-provoking conversation partners, just the type of person you come to this university to meet and learn from. And hopefully tonight we'll all be able to learn from and with you both. I also just want to give a note of appreciation. There's so much individualism from the way people come to this university to the way they remain at it. And when I reached out to Professor Siegel about this topic, she said, well, Linda and I write and think and speak on this together, and we'd like to do this together. And it's such a precious and rare spirit, really, of camaraderie and collaboration. I want to thank you both. And if you want to read the book length version of this talk, you can read the jointly published 2012 book, Before Roe v. Wade: Voices That Shaped the Abortion Debate Before the Supreme Court's Ruling. So that book is timely again. The format tonight, I have a set of prepared questions, and then we will open the floor up to you all, so you can send questions in the chat directly to me or to everybody. I will be selecting among them, calling on people really to take us through the exploration of this question. Everything from the past, the present, the future, the current cases that the Supreme Court has heard arguments from, et cetera. We're going to cover maybe not all of it, but a lot of it tonight. So Professor Siegel and Greenhouse, thank you. The first question I want to ask is about, really, the title of your book puts it so well. For those of us, I was born in 1982, but even those of us who are a generation plus older than me, it's hard to remember a time before Roe. And it's hard to think of a social setting. We talk about a patchwork of laws, but a set of activism, a set of social conflicts and organizing. So if you could tell us the story, the forces that brought the Roe case, that shaped abortion activism prior to Roe, and that got us to what's been the status quo for the last 49 years.
So maybe I'll start and I'll remind Reva that back when we were working on the book that Rabbi Rubenstein mentioned, which, by the way, is available as a free download from the Yale Law School library. I wish we could put up the link, but anyway, she had asked one of her students to read part of a manuscript, and the student said, "Do you mean that before Roe, abortion was actually illegal in every state?" This was news to this Yale law student, and maybe news to some people on this call, but that was true. Abortion was not illegal at the founding of the country, but it was made illegal state by state in the second half of the 19th century. In the 1960s, we'll talk a little more about this, a reform movement grew up. And so there was litigation and some legislation in a few, what we would now call blue states. That phrase, of course, didn't exist in 1973, had legalized abortion, but by and large, abortion was illegal. And that's not to say there was not abortion. There were lots of abortions. There were abortions obtained by women with means. who could fly to London from the East Coast where abortion was legal, could fly to Tokyo from the West Coast where abortion was legal. Others were, the majority of women were relegated to what you might call the back alleys, take their life in their hands to terminate a crisis pregnancy. So that was the situation.
I think it might be helpful to get a flavor of the movement for change. It was doctors in the 19th century who brought us the criminalization of abortion and also of contraception, which was wholly legal at the founding of the country. And it was the medical profession that began the initiative for decriminalization in the 1960s. And the first statutes that were passed actually in the South, everything about change in the period that we looked at looked different in the period before Roe than the world we're currently inhabiting. It starts in the South, it starts with Republicans, not the world we know. In any event, these first statutes essentially left change in the hands of doctors. There was a movement for led by public health figures like Mary Calderon that focused in a very civil rightsy sort of way on the health disparities of a regime of back alley abortions. It was the poor and women of color who bore the brutal brunt of a criminal law regime. And these numbers were made vividly. They were the leading edge of the case for change. And I believe also moved the clergy consultation service. This was the ministry that played a role in the movement for change in the years before Roe to get involved as well as part of the leading edge of a kind of civil rightsy change movement. But the women's movement, also there was a part of the new ecology movement. There was also a strand of this that had a flavor of saving the planet as well. But at the very end of this first burst of change, the mobilizing women's movement got involved and really began to shift the focus onto the importance of making women a center of decision-making authority in the whole situation, which to that point in time was not even really fathomable. And you have in the late 60s and early 70s, the first speak outs. They're actually coinciding with in the LGBT, well, it's the LG movement at the time, the gay rights movement, the early coming out storytelling as well. Both movements are featuring norm shattering, stigma busting forms of protest designed to challenge criminalization. And the early leading efforts for change were all about trying to change law through legislation. But there is in state after state, even as public opinion is soaring in response and really beginning to favor decriminalization, there comes to be, after a certain number of states do change the law legislatively, a period of kind of legislative lockup because there are mobilized minorities opposing change in a number of jurisdictions, generally at that point in time, led by the Catholic clergy. Even though, even in this time period, the polls tended to show a majority of Catholic laity favoring decriminalization, at least in significant degree in a number of jurisdictions. And that's the ecology, the world, the political world within which the Roe opinion was litigated. There were more than one jurisdiction in which this case was in motion. Cases challenging criminal laws were ultimately in motion once legislation started to lock up. And actually, Linda, should we tell a little bit about the other flavor of the other cases? You want to talk a little bit about those? Just to
Yeah,
give us a sense
I mean, one reason litigation was not the first move by the reform community was there was not a lot of robust constitutional doctrine.
How about none?
To rely on. The Supreme Court at that time was just on the verge, but hadn't yet actually recognized sex discrimination as a constitutional harm. Never thought, it had never ruled, even the liberal Warren Court never got there, that discrimination on the basis of sex had anything to do with the equal protection guarantee of the 14th Amendment.
Wealth inequality was the more plausible. The equality claims that were succeeding against these early statutes were on wealth inequality grounds rather than sex inequality grounds.
The courts just didn't look very friendly, but there had been, in 1965, a case from Connecticut, Griswold against Connecticut, that recognized on the basis of a right to privacy, a due process right, for married couples to use contraception. So of course, as people know, that became the sort of foundation for Justice Harry Blackmun's opinion in Roe. But there were other arguments floating around, and there were other cases. There were better cases, there were better litigated cases, there were more fully fleshed out cases, but Roe just happened to be the first in the queue. At the time that Roe was decided, there were 15 or 20 other cases that were waiting the justice's attention, and one of them.
Could we just say one word about the Connecticut case?
I was just going to say.
Yeah, okay.
One of those cases was a case from Connecticut that actually had been cooked up by female law students here at Yale. The formal name of the case was Markle against Abley, but it was commonly known as Women Against Connecticut. And they had 1,000 plaintiffs. They went around, and the students went around and interviewed women all over the state. What is your claim to want to terminate a pregnancy? What harm are you suffering from the Connecticut regime of illegal abortion? And it was a powerful case, had a very good opinion below by Judge John Newman, who was a baby judge then. He's now a very senior judge, but he's still sitting in the federal court in New York. So that, Reva and I feel it was kind of a shame that that wasn't the case that was first in line, because we think it would have made it more a better argument, I would say.
I just dropped into the chat a PDF of the Before Roe book. And for those of you who are interested, it's a documentary style book with a long extended analysis of the sources and question of the sources of abortion backlash toward the back end half of the book. But in the middle portion of the book, you can see the sources from the Connecticut litigation if you're interested. They're actually fascinating to look at. There's a lot of the original documents that came out of the basements of alums of folks from the law school. So you can see the organizing pamphlets and some of the decisions along the way. And it's just an interesting sort of set of snippets of the way in which the case was talked about at in the years just before the Roe decision itself. It also shows you that there were both many constitutional clauses on which these folks claimed, and there were many languages, constitutional languages, very prominently, both the equality as well as the liberty language in which they talked. And where they didn't have doctrine to make their cases, what's so moving about both the Abramowitz case in New York and also the Connecticut case, where they had hundreds and hundreds of named plaintiffs, is that they used women's stories, their depositions, their accounts of the ways in which a regime of criminal abortion injured and altered the lives of men and women. They used these stories to essentially make visible and make graphic and concrete the stakes for Americans in changing the law. And these stories don't make their way into Roe against Wade in any immediate, tangible sense. But I remember reading an interview with Nancy Stearns, who was a lawyer who played a role both in litigating the New York case and also the Connecticut case. I think it was maybe the 20th anniversary, or I don't know, some years after Roe, in which she said that she thought that the storytelling that went on in these movement cases made a difference at the margins in moving the judges to understand that the injury wasn't only to the doctors, but was also to the women involved. And while it seems self-evident to us today, it wasn't intelligible to the law at the time. You have to understand that at the point at which Roe was decided, there wasn't yet even a body of law that treated laws that discriminated between men and women as violating the equal protection of laws. So to a body of jurists who had yet to grasp that as an injury of constitutional cognizance, the fact that laws that criminalized abortions injured or altered women's lives was not yet a self-evident proposition. And so a lot of what these cases were doing was helping making legible, intelligible, meaningful, concrete, moving that fact to judges, even if they didn't write it into the cases. So let's see where to go with this. Roe doesn't have the record of these stories. Roe reasons ever so much narrowly than these litigations in New York or in Connecticut. It reasons in the language of the privacy case law, and it reasons judge to judge. And we don't really have a very good record of the storytelling that went on to move the judges to rule the way they did. But there were many, many years of fighting over that case. And an interesting feature of the case, and I'll just say this, although we have to sort of move our story along, is that for those of you who will hear, no doubt, next summer, the majority on the court say really disrespectful things about the reasoning of the Casey decision, which is the decision that actually shored up Roe in 1992. That case actually managed to grasp a lot more of the kinds of concerns that were moving people to fight to defend the abortion right than the case decided in 1973. And not surprisingly, because as we're sitting here 49 years later, the case decided in 73 was decided really at the cusp of change. And the author of it, Justice Blackmun, only was an early version of the man he came to be after living through the fights over the decision. So it was really over time that as a nation, we began to understand the stakes, and the decisions began to reflect the stakes really for both sides of or the many sides of the controversy. Linda, as having written the biography, can speak to that.
Well, yeah, I mean, maybe we should move to sort of what happened after Roe, which again, I mean, Reva's mentioned a number of counterintuitive facts about the history of abortion, the fact that reform started in the South. Why was that? Because there weren't that many Catholics in the South and so on. We could mention many counterintuitive things, but the notion that the court ruled in January of 73 and that there was an immediate backlash and the country rose up and said, how can we do this? That's the opposite of what happened. Actually, polling at the time showed that after the court ruled, the support for legalized abortion in the country, which was already a majority view, actually grew. So what happened? What happened was the Republican Party, activists in the Republican Party became persuaded that this was an issue that they could manipulate to their benefit and achieve the kind of party realignment in the North that they had already achieved or were far on the way to achieving in the South through the so-called Southern strategy, which was using race and dog whistles about race to peel away from their traditional home in the Democratic Party, white Southerners. And why not do the same thing in the North and peel away from their traditional home in the Democratic Party, urban, ethnic, Catholic voters? That's just a piece of it, of course, but it took about 10 years or more to achieve that kind of realignment and to achieve the social and cultural polarization about abortion that's been driving our politics. It was not something inherent in the opinion or in the court's action. It was imposed on us by cynical politics, actually.
I mean, this is just as we're pausing over this point, there's a tendency to attribute our horrific polarization and in which the abortion issue and the gun issue sit at the center to the decision itself. Sad to say, this account of things, which is actually argued for in great length with a lot of evidence at the back end of the book that we just sent you, this account of things says that actually our polarization is the rich outgrowth of our democratic processes, which happen to ensnare the court in its grasp. That is to say, the Republican Party looking to build out its ranks first used the race card to go after disaffected Democrats in the South, and then used family values to do same in the North. And we actually have a lot of documents showing the first moves to try this in the immediate aftermath of the actually in the lead up even to Roe. There's experimenting. Pat Buchanan experimented with this even in the McGovern campaign. We have documents with him, fiddling around with the experiment, but it famously takes place in the Reagan years. The New Right, Viggory, Weirich, and others actually happen to have on my desk a book by Ronald Balmer called Bad Faith, Race and the Rise of the Religious Right, which is looking into many participants talked about the extent to which the effort to save the segregation academies was at the root of the interest in the abortion issue, which is to say, issues which could no longer be talked about in politics became the locus of drawing evangelicals into engagement with the Republican Party. And abortion was the topic about which they talked, and they wanted to get involved in politics to save the Southern schools along lines of race. All of this was part and parcel of what happens with the struggle over the courts in the Reagan years. So in any event, we're now launched into something much more resembling the present that you're familiar with, the fight over the courts, the effort to realign the courts around frames of originalism and the New Right that have culminated with a few hijinks through the Trump years into the court that we're now facing. I mean, it is not clear that Roe would be hitting the fate that it's hitting for its anniversary were it not for the last 3 appointments. But given our time, Linda, I think we probably should talk a bit about that so we can turn it over to questions.
So this is, I mean, the history that you just laid out, I have a half dozen follow-up questions that I scrawled out for myself. I'm going to exercise a little bit of restraint because it's a fraught and tangled history with many voices you alluded to and brought out, but they are much fuller than are certainly contained in the way that the most of us narrated, and fuller than we can hold in this hour. You kind of gestured towards, okay, there's this case which the court has heard arguments on, and its current configuration is expected to rule on. I'll just share with everyone, Linda's proposed title for tonight was The Long Life and Imminent Death of Roe v. Wade. And I think there's kind of the specter hanging over this conversation. I imagine that the two of you have, kind of in some ways you see much of your careers and the causes you've advocated for and studied, documented, implicated in this moment. So if you could, if we just told a long sweep of story from the founding of the country through the mid-1980s, if you could now take us from January 2022, looking forward, what is the trajectory, or what are the possible trajectories we should anticipate before us?
Yeah, so of course the question is, we will celebrate Roe's 49th anniversary later this month. Well, the 22nd. Will there be a 50th anniversary? The court has a range of choices. In the Mississippi case, which they heard argument in December, the Mississippi law, the case called Dobs, is about a state law that bans abortion after 15 weeks of pregnancy, which is months before fetal viability. Viability is the firewall that was set in Roe and reaffirmed in the Casey decision in 1992 that Reva mentioned. And that basically means that the state is enabled in the interest of protecting unborn life to make a woman jump through a variety of hoops, get kind of biased counseling, undergo ultrasound unnecessarily, and this, that, and the other thing. But at the end of the day, before viability, she has the absolute right to terminate a pregnancy. So what is the court going to do about this? Of course, the lower court had to strike, a very, very conservative lower court, had to strike down the Mississippi law because it's obviously unconstitutional as long as Roe and Casey are still on the books. Why did the court even take this case? There's no court in the country that would have upheld such a law. And the main marker of a case that the Supreme Court exercises its purely discretionary jurisdiction over is a case representing an issue in which lower courts are divided. There's no division, there's a lot of division of opinion, but there's no division of law because the Supreme Court has been totally clear. So the court with the 3 Trump justices last term, the term I write about in the book that the rabbi mentioned at the beginning, Justice on the Brink, decided to hear the appeal in the Mississippi case. So if the court were to uphold the law, which there's every reason to think they will, the court can either be honest about what it's doing and overturn Roe explicitly, or try to gaslight the American public and say we're doing something other than that. We're simply upholding the 15-week ban. What principle would underlie such a decision? What's special about 15 weeks? Why not 10 weeks? Why not 6 weeks? That's the Texas law, the vigilante law, SB 8, bans abortion in 6 weeks. There's a couple of states now getting so excited about this prospect that they have legislation to ban abortion at 0 weeks. That is to say, just a ban abortion. So it'll be very fascinating how the court explains what it's doing and how it justifies what it's doing. Because remember, a number of these justices during their confirmation hearings have said, oh yes, Roe is a precedent, Casey is a precedent. We believe in stare decisis. That's the jargon for we believe in the force of precedent. And if a precedent is going to be overturned, you need a reason. And no reason has actually presented itself. So it's, everybody's kind of holding their breath to see how this plays out. And it's not going to be pretty.
I guess I would just, I'm sure people want to ask questions and I'm inclined to whatever I say here to try to keep it short, but I want to disaggregate 2 different issues. The question of whether there are people of good faith concern ferociously disagreeing about the way in which the law should be organized here, from the question of how the court is making the decisions it's making. And as to the first, I just have absolutely no doubt about it. And nothing that we're saying now or that I was saying before calls any of that into question. At certain points in this story, there are questions of the way in which authority is exercised in the system that, or the rules of the game that lead people who are concerned about the unfolding of the law to that give one pause, And actually looking back at the period leading up to the narrowing and reaffirmation of Roe in 1992, the Casey decision that we were talking about a little bit earlier, that whole period of time looks in retrospect to me fairly, I don't want to sing its praises, but it looks like a moment in which the American legal system sort of shuddered with conflict and held in various ways. And while there's a lot that looks not so pretty about the way in which the the political process handles polarization, some of which we were talking about in our story about the reorganization of the party alignment and the way in which the abortion decision got entangled within it. Politics are politics. The way the court picked its path through all of this, if I'm just being a partisan about abortion rights, all you ever hear about the Casey decision is complaint. But when you look back at the way that decision handled the deep, deep divisions in American society at that point in time, there's a lot to be said for it. Speed forward 30 years in time and look at where we're standing now. And I have to say, I'm much more afraid for our country. I'm not, I was relieved to see that the court sort of stood to roll tonight when it was asked whether or not it wanted to get involved with ex-President Trump's papers. But putting all of that aside, I no longer know what this court is going to do. It's been playing a lot of games with this question in a way that seems not role appropriate and not well designed to pick a path through a controversy that's really one that is hot in the country. And it's not conducting itself with the kind of temperament that is suited to the conflict. I guess I would say it could take apart this viability line and find some other dividing line, but I don't know that it's acting like a court that's looking to find a line that would genuinely make sense to parties that are divided and mistrustful of one another. It's not acting that way in the way that it's handling the situation in Texas and the way that it's handling all of this. And that actually weirdly breaks my heart. I'd rather have the court act like a court than the way that it's acting in this controversy. And but I guess I'm not holding my breath for that. It doesn't really act with the kind of dignity it should be, even if it's going to overturn this. I myself personally have concern about the way the last several appointments were handled. Given the way the last several appointments were handled, it should be acting with even greater caution, but it seems to be acting with less.
Yeah, they've got the power to do it. And, the key moment was the moment they decided behind closed doors, because this is the least transparent aspect of the court's work, to take the Mississippi case, to hear the state's appeal. And we know from the court's website, which gives us a lot of information about what's going on in the court, actually, that the justices took up this case a dozen or more times in the spring of 2021, after Amy Coney Barrett had come on the court and made it clear that there was an anti-abortion majority on the court. And they finally decided to take the case. And that's what started us on the road that we're coming to the end of now in the spring of 2022.
You both have, I want to distinguish between three different forces that you've kind of laid out. And for the first, and the one I actually want to ask the first kind of follow-up question on is like the experience of women. Pregnancies that you mentioned, couples vis-a-vis, but women who are pregnant, who want or need to end those pregnancies and the harms suffered when they're unable to do so, or able to do so only at great expense or danger. The second is the machinery of democracy, how the sausages are made, the partisan politicking, the strategies, the crafting of identity, the exploitation of grievances, et cetera, over 50 years now. And then the third is really the figure of the court as an entity, as a culture, as a set of people, as an institution. And I just want to note the despair, the grief, the sense of betrayal almost that kind of comes through. And both of your people who have studied this institution, devoted your life to thinking about it and documenting and knowing many of the players throughout. And it comes through forcefully and is sad, sad to hear, and is frightening for our country's future. And I don't want to lose sight of that first presence, the voices where you say, women versus Connecticut, the 1,000 named plaintiffs, the case from New York that had hundreds of named plaintiffs. And I would just like to ask you both for a particular story that has stuck with you, a voice, as an individual woman, in the aggregate, someone who testified, someone whose, voices recorded in these documents that has especially moved you and stayed with you, and that you want to take this moment to share, with the dozens of people who are on this call tonight, to say, that as you think about the stakes of abortion in this country, remember this story, remember this person, because I think that'll help ground us all.
Well, people of a certain age on this call will recognize the name Sherry Finkbein. I wish I could see a show of hands, because there will be a generational divide. Sherry Finkbein, who's actually went by her original name, Sherry Chesson, was a young television host on a children's television program in Phoenix in the early 1960s. She had 4 children. She always wanted a big family. She was happily pregnant with child number 5 when she realized that the sleeping pill that she had taken a couple of doses of, a medication that her husband had picked up on a trip to England, was this thing called thalidomide that was not legal in this country, but was common in Europe, and was commonly in Europe causing the birth of babies missing their limbs, because thalidomide in early pregnancy stopped limb development. So realizing this, her doctor arranged for her to have a so-called therapeutic abortion in a hospital in Arizona, but she wanted to make sure that other women in the community who might have be in the same boat but not know it knew about it. So she eventually became public, and the hospital said, "Oh no, we can't now. We can't do it now." They were going to go to Japan. Japan said, "Oh, we can't give you a visa." Now she and her husband, they ended up in Sweden having the abortion. This was a major story. I remember as a kid reading about it in Life magazine. I'm not sure I'd ever heard the word abortion uttered, but it actually served we have her account of this episode in the book. I had to track her down to get her permission to use it. And I didn't know how she would respond all these years later. And she was as warm and friendly as she could be. I'm still in touch with her. I was in touch with her as recently as exchanging holiday cards. And she said, "I'll help you any way I can. People should know my story." So that, I think, is one of the most dramatic. But let me just say something else. Abortion is really, really common. It's a very common experience in a woman's life. About half the pregnancies in America are unintended. That doesn't mean they're all unwanted, but they're unintended. And about, not quite half, but a good number of those end in abortion. The statistics are 1 woman in 4 in America will have an abortion during her reproductive life. So although Sherry Finkbein's story is very dramatic, versions of what to do when you are pregnant and don't want to be, and your only choice is to have a baby or have an abortion, play out in women's lives every day of the week. And I think that's what's important to keep in mind.
There are a couple of questions on the contemporary and near future of the court. I want to exercise my discretion there. And one more question. There's something you mentioned, Professor Greenhouse, early on, which I don't want to blip over, which is that in the earliest days of the American Republic, abortion was legal. And then became not illegal. And I want to understand that process better in a period now of a kind of retrenchment, possibly the abortion right. And the reason, just kind of to a layperson such as myself, that's so interesting is it's easy to tell the story of there are these bad old days of patriarchy. And you mentioned the dearth of legal mechanisms even into the 60s and 70s for addressing sex discrimination. And then we had progress in the form of Roe and Justice Ginsburg's career and others. And the story that you told us, half an hour ago problematizes that because there was a period of retrenchment of the abortion right, of criminalization earlier on. And I think right now in a period where we're staring at a potential, again, restriction of the right, it might be helpful to look back at that earlier period and see if there are things we can glean from it as a perhaps unfortunate parallel.
Yeah, it's a very contested history, but I'm just make clear, yes, abortion was legal, not because there were statutes on the books that say, abortion hereby is legal. It just wasn't illegal. And there was a lot of abortion. And abortions were performed not by doctors, but by what we would today analogize to midwives, women who did this. And so there were a few strands that kind of came together that created the wave of criminalization that swept across the country in the second half of the 19th century. One of them was, Reva mentioned early at the beginning, it was in the medical profession. Took a rather dim view of non-doctors doing this work. It was almost a kind of an anti-competitive thing, you might say. There was an anti-immigrant flavor to it because this was a period of huge immigration from Europe, and immigrants would come and have big families, and the white women of America were having abortions. And it was the kind of replacement fear that, underscores some of what's going on here today. And finally, there was a kind of a moral panic. There was a man named Horatio Storer, and the criminalization of birth control and all that stuff was going on at the same time. So I want to give Reva a chance to elaborate on this, but these were the basic strands that came together and gave us the universal criminalization that we see at the beginning of the 20th century.
Yeah, I mean, the basic framework first of all, contraception, there were no constraints on contraception. The framework was the common law allowed abortion or didn't criminalize it until quickening, which is perception of fetal movement. So it's not the same as viability, but just say at least 3 months. And it was evidentiary, so it was in control. The pregnant woman had control of when she's reporting something. So it's not a right, but it's not criminalized either. And that's the first basic piece of the story. And the second basic piece of the story is that when criminalization really takes off in the mid-19th century, it's got all of the hallmarks of basic status regulation, much talk of control of, it definitely focuses on concern about protecting unborn life, but they could not move the American public to change ways without much talk of enforcing marital duties and ensuring that the population was native as opposed to immigrant. And there's much about the nature of the doctor's exhortation that would be wildly and offensively unconstitutional advocacy today. So, this is all to say that the idea that we've always done it this way is whatever intuitive sense it has is just simply not the facts.
And don't forget, women, of course, didn't have the vote in those years. They didn't have a voice in politics. And so to the extent that women might have been mobilized to speak up for their rights, they didn't have a mechanism for doing that.
The way that women at the time spoke, to the extent they spoke at all, insofar as there was a norm against women speaking in public, it was the language of voluntary motherhood, which did not mean a right to abortion, but it did mean a claim to be able to say yes or no to sex within marriage, which is to say a claim to be able to resist marital rape, which was lawful at common law at that point in time. All of this is relevant insofar as should we reach a point at which the conservatives on the court want to talk about any of this within the language of original meaning or our original constitution or the founding or history and traditions. To the extent that they do start talking in that way, the history that they're summoning, if they're summoning this around the time of the 14th Amendment, those numbers are extremely confused as to what the state law is state by state. It also is the case that what norms are being proposed or advanced by these state laws are very confused. Many of them would not survive contemporary constitutional muster. And the last point is probably itself the most chillingly relevant, which is that the voting base that supported those laws would not even remotely count as democratically legitimate today. So
we've made the
happy note
into the legal and mechanisms. We have two questions in the chat, which I want to really kind of send to you as a final volley here. I want to first pause for station identification again. Thank you, Professors Greenhouse and Siegel, for really just sharing, decades of hard work and accrued wisdom with us tonight at this moment of real significance and potential, sea change in the status of abortion rights in America. And I also want to thank my tremendous colleagues who make this and all our work at Slivka Center possible. Uri Cohen, who you heard from a few minutes ago, our executive director, and also on this call, Jennifer Rojan Wallace, our development director, and Lynn Jackson Quinn, call there in the background, our development associate. It's a tremendous team that puts on this and other evenings. And just to let you know, our next one of these is in February, the 23rd, which is a Wednesday, which will be with Professor Maurice Samuels, rescheduled from November. Professor Samuels is the director of the Yale program for the study of anti-Semitism. It's also a focus of his scholarly work, and the topic will be rethinking anti-Semitism for the 21st century. And so with that, I'm going to send our last volley of questions here. We'll wrap up. I know I have a very hard stop at 9 o'clock. So there were two main questions that have come in. One is from my parents, which is, could a states' rights dimension show up in the upcoming decision? And then another is from Liz Schneider.
No, I'm on another call until 9 o'clock.
Okay, so I'll give you the last word. I know you have to hop off, and Professor Siegel.
Back at 9 o'clock. I can't talk to you now.
Okay. Oh, you're getting a call coming in. Okay. And the other one is from Liz Schneider and Dr. Ben Lipton. What did you think of Nina Totenberg's report on NPR yesterday that the tension between the justices is the highest it's been in 80 years? Can the court discipline Gorsuch for his disrespect to Justice Sotomayor by not wearing a mask? Sir Greenhouse, you're a woman in high demand right now. So those two questions, I know we don't have enough time to address them fully.
Sorry, they weren't supposed to call me until 9 o'clock. I'm very sorry.
9 o'clock. So we'll take your.
I'm going to have to turn off. I'm awfully sorry.
Those notifications are a bear to turn off. I can never quite master them myself.
I'm going to have to leave.
Okay, we will have to savor these. You're urgently needed. Thank you very much. Thank you so much. Professor Siegel, would you mind?
I'm here.
Great. We will take your time for these last
okay.
questions.
I'm here. Linda, you need to go. You should just go.
Yes,
go.
I think everything is okay on her side, just so people know, in case you're right, but there's a 9 o'clock urgent, apparently quite urgent call, and maybe it needs to be taken a few minutes earlier. So thank you, Professor Greenhouse, for your time.
I don't know if Linda, do you know that you're still on screen?
You're still on, okay, there we go.
Okay.
We're all yours. All right.
We're all good. Okay, we have a few more minutes here. Okay, now I'm refocused. So states' rights. So everyone should understand that the basic structure of this conflict constitutionally is a states' rights conflict. So it may appear that what's at issue is protecting unborn life in the ordinary abortion debate sense that, what does anyone ever think is at stake in the conflict over abortion, but a debate between women's rights and protecting the life of the unborn. At the constitutional level, what's at issue always is the conflict between the structure of federal constitutional rights and the underlying ability of states to assert their own regulatory structures, which may privilege protections for unborn life over any other constitutional rights. So what will happen in the Mississippi case is that the court may step back by degrees or completely. It may step back and say, in this case, we're going to allow Mississippi's laws to prevail. It may step back and say, we're just going to move the viability line to some other point earlier in pregnancy. For example, at such point as a woman whatever point will give a woman the opportunity, a reasonable opportunity. Let's just say 6 weeks will be their idea of a reasonable opportunity. That may be giving more ample or latitude to the states to regulate. That's a way of understanding this as a states' rights framework. Or it may say, our Constitution does not speak to this question and leaves it entirely to the states. So in that fundamental sense, this question at the federal level could be understood entirely as a states' rights question. To understand it as a states' rights question, just as understanding segregation as a states' rights question, is to fail to recognize that women have intelligible rights under the 14th Amendment's equal protection and due process clauses, but that's the basic structure of the conflict. In that way, it's the same kind of conflict as we saw in Brown versus Ford. Does that answer the question?
Yeah, thank you. I'm just, one of the things I'm really realizing is there's always this competition for these two planes of framing this between the
Absolutely.
women and the legal mechanisms. And it's not even two parallel tracks. There is something of a tug of war, which one will sit at the center of any analysis.
Whenever the federal government, whenever the court is interpreting the Bill of Rights, embedded in the question is a federalism question, is a question about whether it will give effect to rights that will constrain the ability of states to assert their states' laws in some way.
And then the last question was about the reports of the high levels of internal tensions within the court, in unprecedented levels in almost a century.
It seems very likely that would be so. I don't know how to read the whole story about the masks and the denials that went out about the masks. I have no idea what the truth of the matter is, but I'm sure that the court is trying to circle the wagon and assert its nature as a court and its unanimity as a court, even though if you listen to the arguments in Dobs, its deep divisions as a court were quite on display. When Justice Sotomayor was expressing her dismay about the very appointments dynamics that I was talking about 10 minutes ago, she used the phrase stench to talk about it, which, to say the least, is not the ordinary way in which the justices will speak to each other in oral argument about the court's composition and its role in the decision process. So there is extraordinarily high levels of tension, and it's showing all over the place. So I would believe it.
I do have to ask a follow-up question here because, even from the outside, I'm used to extremely high levels of tension in every American political institution, even within the federal government. If you're a unitary executive, you're used to there's extensive debate, and it seems like there's something notable and remarkable to you about this degree of, okay, we all, those stories of Scalia and RBG being best friends and going to the opera together. But it seems like there's something significant it's a little bit hard for me to grasp about this type or level of conflict within the court itself. And I'm hoping you can maybe explain what's that about? Why is this so surprising and interesting?
Well, I'm being quiet because I'm not sure what I'm prepared to say in public. I do think that there was an extraordinary, there have been changes in the court's personnel with lightning speed at other points in American history by the happenstance of human life and life moving on. The way in which the Trump appointments or Trump/McConnell appointments happened was full of so many procedural question marks, if not irregularities and conflicts, that itself produced stress. Then there have been a series of norm departures going on inside the court, at least relating to, for example, its use of its emergency docket. And that is also producing new levels of stress. They've, around this issue, manifested in the way in which the court has handled the Texas SB 8 case. I don't know if the level of, it would be very hard in a short call like this to prove at any level, with any level of evidentiary base, whether the conservative majority is breaking norms at any greater level than at any point in the recent past. But there has been testimony about the use of that second docket and the way it has changed the court's behavior in the last several years. That is quite striking. That may be part of it. So between the shifting composition and that second docket, those have all introduced strains, but I'm not sure that I could explain the whole thing. It's evident that it's there in argument. The new majority has a lot of power and it's prepared to use it, and that whether that itself is producing strain, whether there's tension because it's felt not warranted, or I'll just pause there. I'm not sure that I feel like I have a public statement to make on it beyond that right now.
The way that you describe those strains as the symptom of perhaps an institution being subjected to unwithstandable forces, in contrast to the way you described the period leading up to the Casey decision of the court being able to shuddering but holding. This is deeply resonant with the other stories of, there was one in ProPublica a few weeks ago about the way local school boards are disintegrating under the pressures that the members are facing, and is a kind of a resonant and a sad one for a certain, it's not quite a Tocquevillian picture, but the of our institutions just being able to hold what they're being subjected to.
Well, that I'll just, as a closing note, I will say that account suggests that it's not anything specific to the court, that really we have a malaise that is society-wide, and that we're having difficulty trusting one another across institutions, and that the court is afflicted like every other institution is afflicted, and that what we're just seeing is maybe even the combination of the rapid fire appointments with the complicated set of circumstances and this set of, or the situation of lack of trust, and that may be what we're looking at, so that a lot of it is not specific to the court, but really, in fact, an affliction that we're all suffering from.
I'm gonna wrap us up here, as we're well over time at 9:05. I just want to point.
Can I just say something?
Yes.
Before closing up, because I don't want to entirely close up on so dark a note. When I listen to the stories about January 6th, something that I'm always struck by, inexplicably, are all of the stories of heroism, not just the people who really put themselves in harm's way, but some of the people who put themselves in harm's way just by sticking to their role, and who stuck to their role, whether they were Democrats or Republicans. And I think I'm really moved by that, in part because I can't account for who does and who doesn't, and where they, and I really have been the most moved by the people, perhaps ordinary, regular people responsible for the administration of the election, who wound up putting themselves and their families in harm's way because they simply did their job as they understood it, and turned into patriots by simply trying to do that and having that kind of role integrity. So I don't just see all a lack of trust, number one. And number two, if there's something to be learned from this longer story of the Roe story, it's that the court itself didn't just make Roe. So the court can't destroy something that it didn't itself wholly make. And it's very hard to talk about a body of law like this in so short a time. But if one has the time to sort of look around in that source that Linda and I dropped into the chat, or that the rabbi dropped into the chat, you will see not just the the advocates for abortion rights, but their antagonists as well. And you'll see a story about law morphing as people in the society as a whole argue with one another, and argue with one another in a way in which doesn't just result in the system breaking, but the system growing and bending over time. And if there's something about the American constitutional order that I find moving and not just despairing of, it's to see it when it's alive and growing in that way. And the hope is that we can find a way to hang on to what I understand it to be there for is to have a resource for us to argue with one another when we can't agree. And what I understand the courts to be there for is to do that as well. So I'm not looking for a court just to agree with me. I'm looking for a court to act like a court. And if I was despairing, it's not because the court is not going to rule my way. I want the court to act like a court, even when it's not going to rule my way. So there's pieces in this story that are our heritage and our legacy, and I don't want to end up just sounding dark tonight. So I'd rather stop there.
Well, thank you for that, about helping us zoom out to wrap our head around, again, not a single decision or a single law, but a body of human argumentation, which is carried on, for 50 plus years, right, well before, and each of us has a role in, which I think is actually part of the hopefulness also of writing together the next 50 years of this story. So thank you, Professor Siegel. Thank you all of you for joining. We'll extend another thank you to Professor Greenhouse. Had to depart, but I would say look out for her on Rachel Maddow tonight.
Yeah, that's where I'm going to go right now.
You may know where those insistent calls were coming from. So thank you all. We'll see you on the 23rd. And in the meantime, may you and your communities be well and be safe. Good night.